Hi, this video is about a United States Supreme Court case on June 5 in which church-affiliated hospitals had a huge win, possibly worth, according to one of the briefs, $66 billion, that's with a B, billion dollars. The court holds that their health and welfare and pension plans are exempt from ERISA. Now this is huge because church-affiliated hospitals and healthcare facilities are now allowed to ignore ERISA's rules, which were designed to protect employees, and we're talking thousands of employees, we're talking billions of dollars. We're talking some of these institutions have for-profit subsidiaries, and it's clear that they are competing in a market against other companies that actually have to bear the cost of complying with ERISA. So this is an important case. The holding in Advocate Healthcare against Stapleton is that ERISA church plan's exemption applies to a pension plan that is maintained by a church-affiliated organization, even though the plan was not originally established by a church. That's what the dispute was about. The original language in ERISA back in 1974 said that a church plan was one that was established and maintained by a church. Then that was amended in 1980 with language saying that a church plan includes a plan maintained by a church-affiliated organization, but there's nothing in there about being originally established by a church. So that's what the dispute is about. Does the plan have to have been established in the first place by a church, or is it just enough that a church-affiliated organization now maintains it? Now, as soon as that 1980 amendment was adopted, right away there were three government agencies that issued interpretations saying, okay, no, it's enough that the plan is maintained by a church-affiliated organization. Doesn't matter who established it in the first place. And these were interpretations by IRS, by Department of Labor, by Pension Benefit Guarantee Corporation, and these interpretations have been coming out now for decades. Now when it gets to the Supreme Court, there's two main arguments. One is that the amendment really just created a subset of church plans and did not change the basic definition that it had to be maintained and established by a church. And three circuit courts adopted that position, which is the argument that's being made by the employees. The other argument is that the 1980 amendment actually created a new category that a church plan can be one that's maintained by a church-affiliated organization even though it was not created by a church. So now we have the court saying that this is actually a new category, new in 1980, not new today, based on the court's rather complex statutory interpretation, which I won't go into it. But this is a unanimous decision by the court. And I found it was interesting, one thing they did not talk about, even though you had three government agencies putting out all of these opinion letters and so on, we would have expected the court to talk about whether courts are required to give some deference to the opinions put out by government agencies. That's long been a topic of discussion in the court, They did not say a single word about that. So, $66 billion later, a good decision from the Supreme Court for the churches, and it's pretty clear that we will not have a level playing field when these church-affiliated hospitals are competing out in the open market. Thank you for watching.